All right. How is everybody? What a great hearing. All right. So we're going to come back. Just to introduce myself, my name is Dr. Mo. I'm a chiropractor in Cedar Park, Texas, and currently serving as the president of Texas Chiropractic Association. I have a couple of guests for you guys here today. Our lobbyist and practicing attorney here in Cedar Park as well, good friend of mine, Josh Mazengel, who's also the lobbyist for Texas Chiropractic Association, will be joining us. And then we also have the legendary Dr. Tice Hergert, record-breaking for all kind of things, one of our favorite past presidents, Dr. Hergert, to give us a little insight on how what he has seen during his time as the president of TCA and all the changes that have occurred regarding this case. So I'm actually going to go ahead and start with our attorney on the board panel here. Dr. Mazengel, you got a doctorate.
Juris Doctor.
Josh, go ahead and give us your feedback. What'd you think?
Well, I think it's probably important to just start with a couple of caveats. One being that oral argument in a case like this is really just the tip of the iceberg. So this is a case that's been going on for a very long time. And even at the Supreme Court level, these battles are largely fought in briefings, in motions. And so as you could tell if you were watching oral argument just now, the justices are pretty well versed in this. And so they're asking some clarifying questions. But, you know, sometimes oral argument turns out to be really important. Sometimes, you know, it's not as important. And the other, I guess, just caveat I would give is that it's often very difficult to determine who's going to win or lose a lawsuit just based on oral argument. I mean, you can really be surprised. Sometimes it will look like the justices are, you know, beating up on a particular side, but really they're just trying to elicit specific responses. Or it's sort of a three-dimensional chess game going on. But with those caveats, what I'll say is that I think this went very, very well for the Board of Examiners and for chiropractors. You know, at one point, you even had Supreme Court justices questioning TMA's standing to sue. You know, even arguing perhaps that the association, the medical association, didn't have standing to bring this lawsuit just on the basis of devaluing a physician's license. So I thought that was surprising. There were multiple references to the marriage and family therapist case, which was sort of similar in many ways, and that was decided in favor of the marriage and family therapist against the medical association. So overall, I think chiropractors have every right to be very, very pleased by what they saw today, feeling very good about it. But of course, we're just going to have to wait, I guess, and see what the court ultimately does.
Dr. Tice, are you with us? You're on mute, Doc. You're still on mute. There we go. So Dr. Tice, give us kind of your history. You've been kind of involved in this battle for many, many years, from the time you were Secretary Treasurer until now. You're all good. So give us kind of what you've seen as far as the history of this case is concerned and what we've been dealing with. Oh, I think we lost Dr. Hergert. Okay, we'll wait till he comes back and go back to that. Josh, they mentioned something in there about the rule changes in 2006. I'm not aware of any rule changes in 2006. Do you know what they were talking about and what that was about?
I didn't specifically catch that argument, but I did at more than one point notice that they were having some discussion about the timeline. And one of the reasons that the timeline is important about when the rule was written versus when the statute was changed in 2017 to include the word diagnose is because part of what's going on here is a sort of procedural question about, you know, the way these rules are brought about, whether they were, you know, whether it's something that ought to be remanded, you know, back down to trial court since the statute has changed. So The procedural aspects of the case are important. And I think that's why you heard so much sort of nitpicking about the timeline, is just because the justices are trying to kind of keep that straight for procedural reasons. But I don't specifically know your question about 2006.
Okay. Yeah, they mentioned that. I wasn't sure of anything of that as well. There we go. We got Dr. Herger back. How are you guys?
The laptop didn't work. It kept projecting it to the screen. It was just a mess. So here we are.
Well, glad to have you back. So, Doc, you've been involved in these battles for many, many years. First, I know you and I have been working on the legislative team for many years, but then you were secretary, vice president, president while all this was going on. So give us kind of the history of what you've seen relating this, and how do we go, from where we were to where we are today?
Well, I mean, it's exciting to see it come to fruition. I remember, what year did Bragg say that this lawsuit was filed? It was like 10 years
ago
or something stupid. And this is the second iteration of the same silly, can chiropractors diagnose? Can chiropractors treat nerves? Can chiropractors do what they're educated and trained to do? And so, just to see it come to fruition, to see chiropractors band together and say, this world's better with chiropractic in it. It's better with chiropractors in it. What we do affects the world in so many ways that we can't even measure it. Who can measure it are our patients. And that's really, when we started this fight, that's what it was about, was, fighting for our patients' rights to have access to chiropractic care, to get the full benefit of our education and training. And if they can limit us to, just muscles and bones, that's a win for the establishment of medicine, and to see how unprecedented it is that this isn't happening in any other state, and it's happening in a state that's one of the largest states in the country, and if they can pull it off here, they can pretty much pull it off anywhere. But it was refreshing to see the faces. I'm glad that this was being able to be broadcast on YouTube. Mm-hmm. We were all able to tune in and watch it. It's great. None of the other court cases, I mean, I've been involved heavily since 2009. I haven't been able to see a single argument until today. And then I missed half at Matt's because my computer was messing up. But, you can take time out of your practice, schedule around it, and see, because this really does affect everything that we do.
Definitely. Great point, Doc. I would like to apologize for everyone for the technical difficulties. We kind of found out last minute that there was some broadcasting issues, and we were trying to resolve them. So hopefully everybody did get to catch a majority of that, if not all of it. But one of the things you mentioned, Dr. Tice, that I found very interesting, and is kind of reminds me of what's happening this year, was how all the chiropractors really united during your presidency, and you guys were able to get diagnosis resolved once and for all. And it's exciting to see that kind of same response happening again this year, of chiropractors really uniting together. And I'm very optimistic that we'll be able to have the same success you had there in your presidency of getting diagnosis resolved, of hopefully getting neuro resolved, not just in the Supreme Court, but also legislatively this year or next year.
You could see a conversation going on. And really, what we tried to do early on, and Mo, you were part of this, is the conversation that we have with legislators and with whoever we're talking to. It's about our patients. It's about Texans. It's about their health. And you could really see today that's where, I mean, there was a pretty blunt question that was like, where is the harm to your doctors? Mm. And has there been any patients harmed by this? And there really wasn't an answer for it, because there's not. This wasn't patient driven. This wasn't complaint driven. This was driven by one organization wanting to control the interests of another. It's I think we're going to see the conversation shift, and we've seen it shift already. That's how we were able to get diagnosis passed. It makes sense to people that when when people see a chiropractor, it'd be a good idea if they could diagnose, if they're trained to do so. It'd be a good idea if they're able to diagnose whether it's a neurological condition. We all have, there's organized medicine, and then there's actual practicing medicine. We have actual practicing medicine in our office today. And it's amazing, because when providers collaborate, it's so much more cost effective for the patient, and the patient has so much better care when their providers work together than if it's you got to go to the MD for that, or you got to go to the specialist for that. You got to, it's just, people don't want to do that. They don't have time to do that.
Great points. All right, so we have a lot of special guests for you guys today, and we have the hero of the hour, our TCA attorney, Matt Woods, and what an amazing argument. We love what you did. Matt, how'd you feel like today went?
Well, first, let me do a mic check. Can you hear me, Dr. Mo?
Yes, sir.
Okay, yeah, no, well, thank you. I appreciate that. I got to say, I want to start by saying it's hard to read the tea leaves in an oral argument, because you never can get inside the judges' heads for sure. But I will say I came away very, very encouraged by what happened, mainly because it was very clear that the judges were informed, not as we all are, obviously, but as far as you can reasonably expect judges to be informed about something so complex. They were well informed. Their questions were smart. They clearly understood the kinds of arguments we were making. And I got to say, I think they saw the potential fallout from the decision and the impact it could have on the whole profession in the state. And so given all of that, and given the strength of the arguments that we put forward, I feel very optimistic about it. I really do.
We felt the same way. It seemed like both the TBCE and TCA had done a great job of preparing and getting the information to the judges through your advice and the counsel from TBCE. And it was great to see the judges so informed and asking all the right questions that we would, want to ask. And it was really exciting to see that they kind of got that we are trying to become more patient, and we are more patient focused in this law, where they're more physician and, income focused. And it was great that they kind of alluded to that as well. So Matt, the big question is, what's next? When do we get a decision? When do we know what's going to happen?
I know, I wish I could crystal ball, but we don't know for sure when we'll get one. I mean, it could be as soon as next week, but usually they take months to issue a decision. They have a number of cases they're hearing at the same time. Probably they've decided which judge will write the decision, or at least the first draft. That person's probably got to go write the decision now, based on some input that they'll all have at a conference in the next few weeks. So I would anticipate that we won't get it this year. It'd be very unlikely to get it this year. I'm hopeful, given how informed they were, that it might come early next year. But the latest it would be is probably June of next year. They try to get all their cases out by the end of their fiscal year, so to speak, before they go on summer break. That would be the latest.
Okay. Is there kind of a average of what we typically see from them of, where we can cross our fingers and kind of keep an eye out, or is it just kind of random during that time frame, just based on?
Yeah, I wish I could tell you. I mean, I would say expect at least 3 to 6 months. That's kind of a sweet spot. So okay. I'd say early next year to spring is definitely possible. The time where it drags out is if there's some internal disagreement among the justices about what the opinion should say or how it should come out. That can drag things out. But look, if I had to say, I'd say expect it. Start building the anticipation around March to June timeframe.
So Matt, there was a lot of, some of the justices seemed very engaged and asking a lot of questions. Some of them just kind of seemed like they were just sitting there, maybe not participating as much. So one of them yawning halfway, throughout. But unfortunately, it wasn't there in your arguments. It was there in the TMA arguments, so that was great to see. But what should we take from that? Is that kind of a good sign, bad sign, or really indifferent? Can we read them based on, you know, their interaction, or yeah, give us kind of a little feedback on that.
Yeah, well, you know, you only need 5 out of the 8 to win. And so I felt like we had at least 5 who were fully engaged and informed. So that's good. You know, some justices sit back and don't ask a lot of questions. But I will say that this was more than I'm used to. There were more justices engaged, informed than I'm used to on a Supreme Court decision like this. And so I take that as a very good sign that that they get the importance of this, right? And, you know, look, I mean, and they're also elected. I mean, they've got an answer for this too, right? So they want to get it right. And I think that's a very good sign.
It was really great to see the questioning and the engagement. We had a question. We're going to try this. Craig, if you're on, I'm going to try to bring you on live to ask you a question about differential diagnosis in relation to blood pressure that you have here. Let's see how this. All right, Craig, you with us? All right. You know what? I'm just going to go ahead and ask the question. They talked a lot about differential diagnosis to rule out issues. I always state the taking of blood pressure is part of that basic exam. But the circulatory system, the circulation system is not part of the musculoskeletal system. We need to take blood pressure because if we lose blood pressure out of our scope, how does that work? How would that, how do we even do vitals? I mean, in those circumstances.
Well, it's a good question. And we addressed not this exact procedure, blood pressure, obviously, but, you know, I did try to work in the blood drawing, which is in the statute, really a circulatory system. And, you know, the kidney punch test, which, you know, it's a nice example because it just is such common sense that you want a chiropractor to do it if it's appropriate in the circumstances, right? And so I think we've laid that out for them. I don't think they're going to address every possible procedure, but I think they're going to be very well aware that whatever they say about VONT, they've got to be very careful that they don't have unintended consequences and take away other things. And there were multiple questions about that that I think indicated they got that.
Well, we have Josh Mazigal, our wonderful lobbyist, on board as well. I want to see if he has any questions for you. I'm sure he has some great legal questions here as well.
No hard ones, though, please. I mean, I've gotten a lot of hard ones.
Just name all the justices in alphabetical. No.
It's not a sobriety test, I hope.
So one of the issues that cropped up that I was frankly sort of stunned by, because as I can recall it hadn't come up, you know, at the appellate level, was whether TMA even had standing to bring a case like this based on, you know, just the devaluing of a physician's license, you know, by allowing chiropractors to do this or that. Is that something that we were expecting, and is that the sort of thing that might get the case remanded back down to trial court, you know, kind of chutes and ladders, like start back at square one, or what are your thoughts on that?
Well, no, it's a good question. We have made some arguments about that in the briefing. Just for background, for those, you know, who don't live and breathe in the law like Josh and I do, there's a concept called standing in a lawsuit. And the basic idea is that before you can bring a lawsuit, you've got to show that at least claim that you personally were hurt in some way. Kind of like you can't go be the Lone Ranger for somebody else, right? You got to show you were hurt. And there's been this lingering question over, frankly, all of TMA's lawsuits, which is, how are they really hurt by any of this? The physicians, their members, right? How are they injured if a chiropractor does VONT or treats a subluxation complex? I mean, it's a little absurd. And so they've always just kind of said it, but not really proven it. And I think what you saw here is that some of the justices thought maybe they hadn't done enough to prove their standing. And it's actually somewhat common for judges, if they don't, sometimes they don't really want to address the merits of an issue, they can basically dismiss the case and say that it really should never have been brought because there was no standing. And so I think what you saw was at least one or two justices toying with that idea of maybe you just throw the case out because there's no standing. And if that were to happen, it would undo the decisions that have happened so far. So essentially there wouldn't be jurisdiction for the courts to consider it. Now, could it start all the way over? That's possible. But the decisions that have been made so far would all be null and void.
Matt, I have a question here. We're going to try this live and see if it works again. Dr. Larry Wyatt. Doc, if you're on, we're going to let you ask your question live. If not, I'll go ahead and ask it. How important is the damage to DCs caused by a negative ruling? How important is basically how much hurt can we feel from this at the end of it?
Yeah, well, and I can read the question. I think the spirit of the question is how much is that potential damage going to influence their decision, right? And I tried to point out that, look, we really don't, it's hard to say for sure what the damage would be, but we know that it could potentially be very serious. And I think the answer to that is that these justices, by and large, try to make a decision based on the law. You know, I do think that they do try to do that. Now, do they consider the practical impact of what they're doing? I think they do. They can't help but consider it. But I do think, by and large, they try to get the law right. So, to me, the main benefit of pointing those things out is that it really gets their attention. I think it motivates them to make darn sure before they go write something and issue an opinion that could upend a profession, they got to get it right and really think it through. And that's really the intent of that. And of course, you also hope that on the margins, it has some influence and maybe deters them from doing something that would cause a big change as well, because they are elected officials.
I'm going to keep going back to the questions here. We have a few of them coming in. Dr. Gray, your question didn't come through. All it says is Mr. Wood. So if you want to retype it, we'll go ahead and answer the question when we get the whole question. Dr. Campion, how are you? In Matt's opinion, should our board continue going forward with recognizing specialty certification within the chiropractic profession to address the TMA's response to the TBCE does not even recognize chiropractic neurology as an example?
Well, you know, I will start by saying that's probably a little bit outside of my expertise, you know, the pros and cons of recognizing specialties. I mean, it would take away one of the arguments that TMA made, although I think we also probably could expect TMA to file a lawsuit in response, right, and probably try to invalidate that rule. So, you know, it could cause more potential damage than good, but it's really not for me to say whether specialties should or shouldn't be recognized. I will say that two things. One, I'm sorry I couldn't address that point during the argument. 5 minutes flew by, and there was a lot that David Bragg said that I would have loved to have just jumped on like a junkyard bulldog. But I didn't have time to do it, and I had to prioritize what I addressed, and that was one of them. The other thing I would point out, which is interesting, the American Medical Association filed a brief, it's called an Amicus Brief, or friend of the court, you know, basically siding with TMA in the case. And they attached 2 agreed cease and desist orders between the Texas Medical Board and 2 chiropractors in Texas. And essentially the medical board had thought that these chiropractors were improperly holding themselves out as medical doctors. And it related to chiropractic neurology. In those agreed cease and desist orders, the medical board expressly agreed that those chiropractors, there were 2, could continue using their diplomate of the American Chiropractic Neurology Board designation in their advertising. So even the medical board in those cases didn't think that needed to be stopped, right? Just saying that you had the designation. which is interesting because I do think that it shows that that is a legitimate thing for chiropractors to do and use, and even the medical board seems to agree with that. So, just food for thought.
Thank you. All right, next few questions coming up are going to be from 3 of our board members. I'm excited. Dr. Bonine, I saw a lot of engagement by the justices during the arguments of Mr. Bragg. How do you feel about how they treated him, and how do you feel about the justices saying, that sounds expensive?
Well, I'm always glad when a justice thinks something the other side is saying sounds expensive. So I was happy to hear that. You know, it showed me that justice was thinking about the practical implications of the decision, and whether that really was intended by the legislature when they adopted this law. So I take those as good signs. I do think that Bragg got some tough questions, and you know, they didn't hold back on him. They really did not. And again, you know, you always have some concern just because the Texas Medical Association is so big and powerful. You always have some concern that the justices, being elected officials, might show some deference or might hold back. But I didn't see any sign of that. I got the impression that they were engaged and that they were looking at this on the merits. And I think that showed in their questioning of David Bragg.
So next question, I think you know him well, our litigation chairman, Dr. Hollingsworth. He has been involved in this process and has put in so many hours, and we really appreciate his time and his efforts. But his question is, procedurally, can other amicus briefs be submitted and considered after oral arguments?
Well, procedurally, the first thing I want to do is thank Dr. Hollingsworth, because he has been an invaluable asset to me at every step of this process. He and I are foxhole buddies at this point. We have sliced and diced TMA's arguments every way you can imagine. And a lot of the good things that I had to say, and that were in our briefs too, came from him or were inspired by him. So I want to start by thanking Tom, first of all. But to answer his question procedurally, can we get new amicus briefs? It is possible. It's not disallowed. We are reaching the moment where the court is starting to, I think, to circle the wagons a little bit and come to a decision. And so it's not clear how much impact it would really have. So unless there was something just, you know, some kind of firecracker you could let loose that might have a big impact, it probably isn't worth doing at this point. We've got a really good set of amicus briefs so far.
Excellent. All right. Thank you, Tom, for that question. And thank you for all the time you've put in. I think you've been involved in this probably for the whole 10 years of it. So thank you. All right. Next one from one of our other board members, Dr. Hillman. They were so engaged, but I'm curious if the justices have to still seek out more information prior to their ruling.
You know, I think they've got what they need at this point. I would be surprised if they need to seek out anything else. So, you know, they because these questions about interpreting the law, you know, they could do their own research. You know, they could go crack open textbooks and do things like that. But I suspect at this point they've probably got what they need, and now they just need to decide what the answer is.
Dr. Christie, I see your comment, but it just says statements. I don't know if it failed to come through. So if you don't mind retyping it and sending it through, we'd love to ask that question. All right, Dr. Tays, how are you? How strong is Braggart's argument that Texas chiropractors cannot diagnose the subluxation complex?
I think it's very weak. It's very weak. It's a technicality, very technical reading of the law. And it's one that the Supreme Court has already rejected in a different case involving marriage and family therapists, where there was a very similar argument made by TMA. And they said, well, come on, the law lets you, in that case, it was remediate someone's mental problems. You can't do that unless you know what the problems are, right? And so I think if push came to shove on this issue, I do think the court would allow diagnosis of subluxation complex. It does not really have to decide that issue, though, in this case. So I I will tell you that the board has rules that authorize diagnosis of the subluxation complex. So as the law stands now, and as I expect it to stand after this decision comes down, it's fully within the scope.
All right, Dr. Gray, I may just be unaware of the previous argument, but was the attention given to the language not including being able to diagnose the subluxation complex and only improve it anticipated, or was this an approach by the TMA and Bragg?
That's an argument he's been making for a while, yeah. And it hasn't really gotten any traction anywhere. And so, you know, it crops up every now and then, and we keep playing whack-a-mole and whacking it down. But so far, no court has ever endorsed that view.
Dr. White, having testified in the first TMA case myself, I wonder what the previous decisions might have on this case.
Yeah, I'm thinking this may be the diagnosis case that we're talking about here. And the needle EMG and MUA. I think that the issues are different enough that I don't think that the earlier case is going to have a big impact on this. I don't. The only thing that I will say for sure is that the earlier case does establish that diagnosis is allowed. And you can see in the court's questioning that, especially after you know, the legislative affairs team got diagnosis in the statute, that was important to them. It was important on differential diagnosis because it made it absolutely clear beyond any argument that diagnosis is allowed. And what's a differential diagnosis but just one type of diagnosis? So that win legislatively, I think, is definitely showing signs of helping in this lawsuit.
Is it possible that a negative ruling could limit very specific parts of neurology diagnosing, but still allow DCs to diagnose a disc herniation, radiculopathy, sciatica, etc.?
I think it is possible. Yes, I think it is possible. We'd have to see exactly what the court says, because the court can strike down a rule from the board, and they can do it with some sweeping language about how nerves are outside the scope, or they can do it in a very surgical way and say, we just don't like this one test. We think that's outside the scope. So a lot depends on what they say if there's a negative outcome. But I do think that there are ways that we could, you know, lose a narrow issue, but still have some of those procedures, maybe all of those, or those conditions within the scope still.
Sorry, Dr. Christie, I think we're having some technical difficulties with your question. This time I got a sentence, but it's still, Ellis says, I would like to make, and it doesn't complete. So I apologize. I'll be looking for the entire question down the line. All right. Dr. Hillman, what was he addressing with the 2006 changes? We were wondering the same thing. We have no idea what he was talking about in 2006.
Say that again, Dr. Mo. Sorry, my audio cut.
That's okay. What was he addressing with the 2006 changes? During the hearing, Bragg talked about the 2006 changes to the law, but I'm not aware of it.
Yeah, so that's another one of those technical arguments that TMA is trying to make. So the point there is in 2006, that's when the board adopted the definitions of subluxation complex and musculoskeletal system. Those are the definitions that are at issue in the case. So, you know, one of the points that TMA has made, and he made it again in the argument today, is, well, gosh, if we take away those definitions, is chiropractic really so bad off? Because you didn't have them until 2006 anyway. They can't be that important. But the reply to that, which I didn't get a chance to make, but I don't think the court really is going to fall for that trap. The reply to that is to say, well, yeah, but those rules reflected the practice at the time and the longstanding practice. And so, yes, taking them away in the process takes away that longstanding practice, right? And so, yes, it's not so simple.
I see Dr. Tice is back with us. Dr. Tice, I'm sure you got a lot of burning questions. I'm going to let you ask the next one of Matt.
Well, I don't have any questions for Matt. I just want to thank him for the, however many years of service. I feel like Matt's one of us. He needs an honorary chiropractic degree from someone for the amount of experts that he's had to go through for these 2, 3, 4, however many cases we've had. So thank you, Matt. You're a stud. And I would like to take credit for hiring you, but I can only take credit for hiring you the second time.
I appreciate the kind words. Thank you.
I love winning horses and just keep winning. I was blown away. I mean, what we saw today, really you could see all the work that was put in on behalf of yourself and on behalf of the association and the board as well. It's serious business and you get that more than anybody. So I thank you for your help and I mean at some point I'd like this relationship to end, but I want to end on a good note.
Well, I appreciate that, and I will tell you that when I started working for TCA, I want to say it was 10 years ago. Unfortunately, these battles with TMA have been going on a long time, but I didn't know that much about chiropractic. My mom went to a chiropractor and swore by her, but I had not personally been. I had been multiple times since, and I've just been blown away by you all. I mean, your level of knowledge, the care and dedication you show to your patients, and really, the arguments we make to the court, how important you guys are to the healthcare in the state and in the country. I mean, when I say those things to the court, I'm saying them because I really believe them. I mean, they're coming from a place of passion. And so I love representing you guys. And I also love it when we can, kind of give TMA a black eye in the process, right? So,
I'm all for that.
Yeah. So anyway, thank you for the kind words, though. I appreciate it.
Absolutely. Thank you, Matt.
Well, Matt, I believe the next one is actually a compliment to you as well by Dr. Gregory from the Florida physician who's also a licensed chiropractic orthopedist. Has really nice things to say. Seems like he was very impressed. So thank you for those kind words, Dr. Gregory.
Thank you.
Yeah, I don't know why I'm thanking him. You should be. There was you. But.
Yeah, thank you. No, thank you. And I will say, I mean, there's a compliment in there for the justices, and I will say I thought they comported themselves very well. I was impressed with the justices too. So, it's always a good feeling. You don't always get that feeling from judges, and I came away very happy with the reception that we got.
Oh, well, thank you, Dr. Christie. Dr. Christie also would like to give numerous positive comments, so thank you for that. All right. Jason Ray, fantastic. You did a great job. What do you make of the judge's references to diagnosis a misalignment tumor? Diagnosing a misalignment tumor.
I think it says malignant. I think I'm looking at the.
Oh my goodness! I'm sorry. I'm trying to read on a small screen here.
Yeah.
Malignant tumor. Thank you for correcting me.
Bifocals.
I know. As you can see, I'm getting closer and closer to my screen at every one of these meetings. Do you think all the judges understood that a DC's need to determine whether pain or other symptoms are the result of the musculoskeletal problem versus a tumor?
I didn't get a chance to address the tumor point or tumor example directly, but I do think they got it. I mean, I think they understand that when somebody comes in with pain or a headache or numbness or tingling or lots of things, I mean, I think they understand that you're ruling things in and out, and tumor might be included in that. I think their concern was more about, where does the testing stop? How much testing how far down the testing path could you go to rule out a tumor? And, I tried to address that by telling them, look, part of what you're deciding is the scope question, but there really is a second layer to that. Even if something theoretically is within scope, it still has to be within the training and experience of chiropractors. And so I wanted them to know, just because you side for us today, you're not committing Texas law to a whole bunch of stuff that isn't really before the court. And that's not, obviously we're not closing the door on those things, but the courts don't like to make big sweeping pronouncements. They'd rather keep it focused on what's in front of them. And so I tried to make sure they knew they could do that.
Okay, next question from Dr. I apologize if I mispronounce it, Odom, I believe, Odom. I don't know if this was addressed but was the argument made in diagnosing entrapment pathology and entrapment neuropathies versus radiculopathies versus neuropathies versus myelopathies, the diagnosis of treatment or referral of these conditions?
So we did not address all of those in terms of differential diagnosis in or out of scope. We did in our briefing talk about nerve entrapment disorders as being within scope. And so, I think we put that in front of the court. So the court should be aware that that is something within the scope of practice for chiropractors, and that can cause things like, radiculopathy and things like that.
So Dr. Carmen has some great words. It's always good to see you out, Doc. God bless Matt. I agree. I appreciate the comments. Thank you very much. But Dr. Mo, you don't have to read all those. I mean, there's probably half your audience is probably like, come on, this guy's gotten enough praise, right? So I appreciate it. But thank you everybody for that. We appreciate it. All right. Martha Bronson, the definition of CMT is a manual form of manipulation to influence the joint and neurophysiological function. This means a subluxation. The definition of an OMT is the manual form of manipulation to relieve or alleviate somatic dysfunction. This means musculoskeletal condition. What impact would this have on coding compliance, such as billing CMT codes, Medicare, if TMA wins?
Yeah, it's a good question. We raised that issue in our briefing to the court because we told them that based on CPT coding, chiropractic manipulation is to improve the joint and neurophysiological function. And incidentally, it's an American Medical Association definition. And so we pointed that out, and we have told them that, depending on how they write their opinion, if it came out the wrong way, there might be some question about chiropractors using that billing code. And so the justices should be aware of that. And we've tried to show them all the different ways that if they go the wrong way on this, it could reverberate throughout the profession, and that is one of them. But to my earlier point, we'll have to see exactly how they write a decision, because it's possible that you lose on an issue, but it's very narrow, and it may not take that away.
Excellent. Dr. Christie, Matt Wood did a phenomenal job. Am I allowed to send a nice note to the 4 justices that I know?
I would recommend against contacting justices about the specific case. Judges in Texas walk a little bit of a fine line. They're politicians, so they have to raise money. They have to be responsive to what people want. But they also try, I think, and in some cases it's more convincing than others, to make it about the law. And so there's the appearance of favoritism or something like that they try to avoid, especially on the Supreme Court. I mean, they're all very serious lawyers and judges. So I would recommend against it. But if you saw them and shook their hand and said, "Thank you for really giving that case the attention it deserved," I think that's fine. But look, it's up to each person. They're your representatives. So.
All right. If anybody has any last questions, go ahead and put them in the Q&A box. Last comment we have on here from immediate past president, Dr. Carpenter. Once again, just saying how much he appreciates all the work, Matt, and your great job. So we couldn't have done it without you, and he's absolutely correct. We really appreciate it. All right. We have one more that just popped in right as I'm closing it. Can you elaborate more on the MD license privilege argument? That's a good question, Doc.
Yeah, so the privilege argument, it kind of crops up in different ways, but what TMA's basic point is that the legislature, when it adopted medical licensing laws, said that practicing medicine is a privilege, not a right, which means basically the legislature has a lot of discretion to define who can do it and who can't. And so, part of what they argue is that that chiropractors haven't earned that right to do what physicians do because they don't have the training that they have. That's part of how it crops up. The other way it crops up is they say that they have a privilege to practice medicine and therefore they have standing, which is that issue we talked about earlier. They have standing because when chiropractors do things that are within the scope of their license, it somehow devalues that privilege in some way, which I think is a bunch of hocus pocus. But that's the argument they make.
All right. We have two questions. We're going to go ahead and wrap up with those two. If you have any other questions, feel free to send them in. We'll have the TCA staff try to respond to those for you. If there were a judgment against the chiropractic profession, what would be the implications to the VA and military healthcare system be? Is there a line in the sand where the state ruling would have no bearing?
That's a really interesting question. I don't know the answer to that. In a non-military setting, it would apply, the decision would apply throughout Texas. It's Texas only. But the military is federal law. Federal law trumps state law if there's any conflict. And so I don't know the answer to that. It's depending on what federal law says about chiropractors and who can provide care, I think, in the VA system.
Why do we not have privileges as DCs?
Well, that's a loaded question. I would say you do have privilege. It's just, TMA doesn't want to acknowledge it. That's the fact.
Well, I'd like to start off with thanking the panelists. Thank you, Matt, for your amazing work and the great arguments today. Thank you, Josh Mazingale, for always keeping an eye on us. And we're going to be hearing a lot more from Josh over the next 6 weeks or so as we transition into the legislative session. So stay tuned. We're going to have a lot more town halls coming up in relation to the legislative efforts that we're going to be making through the PAC. So stay tuned. Also like to thank our past president, Dr. Thijs Hergert, for joining us today. And always a thank you to TCA and the staff for the amazing work they do. Just remember, TCA is the one sitting out there fighting the defense for all us chiropractors here in the state of Texas. As you guys saw today, we are always there fighting the battles for Texas chiropractors. And so if you're not a member, please join, give us the support, and let's fight this battle together. And you don't have to be a licensed Texas chiropractor. You could, be a friend of chiropractic. You could be a franchisee owner. You could be an office employee. You could just be a CA or an employee of a chiropractic office, and you can still join the TCA and support the efforts. And you can do that as simple as getting on the website, chirotexas.org/join/now. I'm going to have Jeff go ahead and put that in the chat for anybody that missed it. So you can go ahead and join TCA today. Also want to thank all the chiropractors throughout the state that really stepped it up with the CDI fundraising to help us be able to fight these battles for Texas chiropractors. We set a goal of 50 was broken. We set a goal of 75 was broken. We are sitting at 85. We're going to try to get it to 100. So if you haven't participated yet and you'd like to see your profession defended and you know, the TCA to continue to do the battles that we need done for our profession, please get on your phone right now. Text Chiro TX, CHIRO TX to 56512. That's 56512, Chiro TX. And that'll take you to the webpage so you can become a contributor to CDI. There's opportunity to join the 100 by 100 club, which is our kind of leading sponsors of chiropractors that really help us kind of move these things forward. And we'd like to thank all of our 100 by 100 members. And then also a big thank you to the Texas Board of Chiropractic Examiners and their president, Dr. Mark Bronson, for all his hard work and all their hard work in helping protect our profession and push our profession in the right direction. We really appreciate them. Final thank you to everybody that's tuned in and is paying attention to what's going on and is continuing to support the TCA. Thank you guys. Stay tuned. We're going to have a lot more information over the next couple of weeks through our pack regarding the legislative fun stuff that are going to be happening. So stay tuned. We'll be back with that. And thank you, panel, for your time. And Matt, once again, phenomenal job. We'll look forward to that. Hopefully very, very positive results coming out very soon.
I hope so too. To represent TCA, I appreciate it.
Thank you.
Okay.
Hope everybody an awesome week.